As it pleases the court, my lord. Now, the structure of my application, or my application is structured as follows. There's an introduction. There's a factual background of the case. That's where we're making our submissions. And we then conclude and come up with a prayer. It's a very short process, my lord. Now, as I'm saying, my lord, we have decided to name this an application in terms of Section 35(3) of the Constitution of the Republic of South Africa, Act 108 of 1996 in the term lines. The reason for this is because that is where the gist of this application is based, my lord. The introduction here simply states that, or we're stating in our introduction that Mr. Ncube is approaching this honorable court with an application to request this court to allow him to be assessed by a dentist or a similar physician before he can start with his cross-examination on the new evidence which has been introduced by the state. Basically, this assessment, we regarded it as a way of a preparation and to gather evidence or to amass more information for him to be able to challenge the state's case. I'm not so sure whether the application is opposed by the state or what. We'll hear, but the factual background of the case are as follows. Now, at the center of this application is the fact that the state has introduced new evidence. That is what we're maintaining, which they had sought to use to prove the identity of the applicant, who the state alleges that it is one of the perpetrators who is complicit in the commission of the offense, that in the commission of the offenses that are alleged against him. Sorry, my lord. Now, apologies for that, my lord. Now, we're submitting that the applicant, and this is common cause, pleaded to the charges which are leveled against him on the 18th of July 2023. And this was after the state, as per procedure, furnished the defense with information which enabled him to plead. Up to date, the state has led in more than 60 witnesses, and the trial has progressed for almost 23 months and 2 weeks. We almost at 2 years, because on the 18th of July, we hitting exactly, on the 18th of July this year, we're hitting exactly 2 years since the trial had begun. Now, in the month of April, the prosecution came up with new evidence that they provided to the state and intimated that it intended to supplement its evidence therewith. Now, the evidence that was submitted by the state to the defense as it relates to this application comprises of photos which were downloaded from the applicant's cellular phone, which was found in his possession when he got arrested in 2015 in a case that, in a different case. Now, that information is already on record. Now, we're noting, my lord, that the state has been in possession of the above-mentioned information for more than 10 years. When I say the state, I mean the police. Has been in possession of this new information that is now being introduced in the month of April 2025. They've been in possession of such information for more than 10 years, but for the team of prosecution that are handling this matter here at court, I need to be very sincere with them. They've been in possession of this information for almost 6 years, because evidence that has been placed before this court is that they started to prepare this case since 2019. That is as per the evidence of Brigadier Kininda. My apologies, my lord. My colleague advocate Mark Baloyi is respectfully whispering to me that it is actually not in 2019, but it's in 2020, which is almost 5 years. And that have been in possession of this information, of this new information that they are introducing, or that they've already introduced, that we only received on the month of July 2025. Now the photos, or that information, that new information, as I'm saying, these are download of photos, are depicting the applicant, that is now accused number 3, smiling. He's wearing a single braided dreadlock hairstyle and a long-sleeved striped t-shirt. Now, what is notable here is that the state never at any moment, the state never at any moment indicated to the defense the purpose that they intended to introduce this new evidence for. In other words, we only got handed over with the information, but there was no indication the reason why such information had to be read. And when I say we, I mean myself, had always been under the impression that probably what the state would want to show, or the purpose for which this new information is being read, was the dreadlocks that were worn by accused number 3, or the applicant, allegedly at the time of the commission of the offense, and probably his skin color, which is beyond reproach. Now, there was a vehement objection from the defense for the introduction of this new evidence. However, the decision went in favor of the state. Subsequent to that, this is just the background. Then the state proceeded to lead this new evidence. And it is only then that it became clear what the purpose for the leading of this, or what was the purpose for the introduction of this new evidence was. And that was to prove that the applicant had a gold tooth, presumably when the offenses were allegedly committed, and is linked to the commission of these offenses through this identification with the gold tooth or teeth. Now, as I've said, that the defense never even had the slightest idea that the purpose of this new evidence were to prove this allegation that at the time of the commission of the offense, the applicant had a gold teeth. Now, subsequent to the state's application being granted, then the state went on to read the evidence of Warrant Officer Mabaso specifically on this item. And he gave his testimony, which testimony is on record, and having completed the proffering of his testimony, then the defense requested an indulgence from the court to prepare for the defense, for its defense in this new evidence, by holding in abeyance the cross-examination of Warrant Officer Mabaso, pending the information, or pending the making available of the information that would have enabled the applicant and myself to challenge the state's case in the allegation that the states were raising against the applicant. However, the court ordered that the formal application should be read, and that heads of arguments should then be submitted in that regard, my lord. Thank you. Now, the pillars of this application, my lord, or this application is based on following pillars. That's now the Constitution and the case law. Exclusively from the constitutional courts, cases from the constitutional courts. Now, the Constitution of the Republic of South Africa, my Lord, Act number 108 of 1996, in section 35 provides as follows. I will only quote those sections that are relevant to this application. Now, section 3, subsection 3 of section 35 reads as follows. Every accused person has a right to a fair trial, which includes the right, subparagraph A, to be informed of the charge with sufficient details to answer to it. Subparagraph B, to have adequate time and facilities to prepare a defense. That is the leg on which we are standing as we are bringing this application, my Lord. Well, there are those other factors, C, D, I think it's up to J or O. Now, subsequent to that, and immediately after section 35, then section 36 of the Constitution also provides as follows. Now, the limitation of rights. Section 36(1) says, the rights in the Bill of Rights may be limited only in terms of law of general application to the extent that the limitation is reasonable in an open and democratic society based on human dignity, equality, and freedom, taking into account all the relevant factors, including the nature of the right, the importance of the purpose of the limitation, the nature and extent of the limitation, the relationship between the limitation and its purpose, and less restrictive means to achieve the purpose. Now, paragraph 2 of section 36, which is the limitation of the rights, states that, except as provided in subsection 1 or in any other provision of the Constitution, no law may limit any right entrenched in the Bill of Rights. Now, I've gone through the Constitution to find if there is any clause that is in the Constitution that deals with the limitation of right. I could not find any, my Lord. Now, we are further saying, my Lord, that the right which the applicant is approaching this court on is a right that is contained in Chapter 2 of the Constitution and falls within the ambit of the Bill of Rights. I'll come and deal with the content of the Bill of Rights. Now, the right that the applicant is requesting the court to afford him ensures that he is not disadvantaged in the conduct of his case and has a reasonable opportunity to prepare for his case and challenge the prosecutor's evidence. That is very succinct. It is beyond reproach. The provisions of section 35(3)(b) are very specific, my Lord. And we're bearing in mind what the Constitution says about the limitations of the rights that are contained in the Bill of Rights. Now, number 18, this is an emphasis of what has been said in our introduction, that the applicant had at no point anticipated that almost 23 months after the commencement of the trial, the prosecution will confront him with entirely new evidence, which would have required him to start the preparations of his defense in the matter on this new evidence, as if the matter is starting from the beginning. Now, this is very clear, man. When a person gets confronted 23 months into the trial and the state having led more than 60 witnesses, they come up with exclusively new evidence. What does that mean? It simply means that the accused or the applicant in this case gets taken to the very first day on which he's supposed to be pleading. He has to start to prepare this trial or his defense as if this matter is starting de novo, specifically with the introduction of this new evidence matters. Now, what is worrisome, again, is the fact that the prosecution offered no compelling reasons why this evidence was not made available to the defense and its purpose in time, so that the defense could deal with it timelessly. We are submitting, my Lord, that it is therefore fair that it's late availing of this, the late availing of this information to the defense should be reckoned as a factor which entitles the defense to request a reasonable time to prepare on it. The Constitution gives the applicant that right and entitlement. Just a very quick one. I would have been expected to cross-examine Mr. Mabasa immediately after he proffered his evidence. But the worrisome factor is I had no opportunity even to take instructions from Mr. Mube, accused number 3. So how could I then have been in a position to there and there start to cross-examine Mr. Mabasa with new evidence that he proffered, that we did not even have the slightest idea what the nature of evidence would have been, my Lord? That would have been very grossly unfair to the accused. And beyond that, the court would have noted that at one point or the other, accused kept on requesting an indulgence that I should come and see him. He came up with a number of issues that we need to deal with before we can start to cross-examine Mr. Mabasa. It would have been very unfair and very prejudicial to this accused person if I immediately started to cross-examine Mr. Mabasa on this new evidence, because I would then have been found wanting. And a counsel that is found wanting in his cross-examination, I'm just wondering if that could be said to be a fair trial at the instance of the accused person, because I would then have been misrepresenting him. And that is what the Constitution says, my lords. Section 35(3) says, every accused person has a right to a fair trial, which includes the right to have adequate time and facilities to prepare for his defense. Now, the court decried the fact that in the course of trying to brainstorm this issue, the court made mention of the fact that it knows, it's not aware, not really, does not know, the court is not aware of a provision in the Criminal Procedure Act that deals with the application that I said I would bring before court after my request was turned down. I had a very detailed look at the provisions of the Criminal Procedure Act number 51 of 1977. It is indeed so, my lord, that there's no provision that deals with an application for a cross-examination of a witness who has already testified, that his cross-examination should be put in abeyance until such time that the accused, on whose behalf that the witness must be cross-examined, has had an opportunity to prepare his case and gathered all his evidence and had all the facilities to cross-examine that particular witness. To be fair, I could not come across that provision, but that's not the end of the thing, my lord, and I will deal with this aspect later on. However, Section 167 and 186, that is 167 and 186 of the Criminal Procedure Act, although they deal with the recalling of witnesses and the subpoena of new witnesses, there's a rider that is contained in these provisions, and that rider is as follows. If his evidence appears to the court essential to the just decision of the case, that is what 167 says. 186 says, if the evidence of such witness appears to the court essential to the just decision of the case. The operative phrase here is just decision of the case. Now, in amplification of what is being said about this provision, this is what we're submitting. That although the two provisions of the Criminal Procedure Act do not deal with affording the applicant a reasonable opportunity to prepare for his defense, in order to challenge the state's case against him. The evidence that he requested the court to allow him the opportunity to amass is essential to the just decision of the case. And this is exactly what Section 167 and Section 86 says. This deals with the justness of the decision of the court in respect of the case. Now we are submitting, my Lord, that a just decision is one that is based on the ethos of the Constitution. It is one that is arrived at on the principle of the rule of law. It is one that is fair in terms of Section 35(3) of the Constitution. And all these factors are embodiments of a fair trial. My Lord, we're not requesting something fancy, something trivial, something unheard of. All that we're requesting is that we be afforded an opportunity that we should go and prepare for our defense. We be afforded the opportunity to have adequate facilities to prepare our defense, and then from there we proceed with the cross-examination of Warrant Officer Mawasa. And I remember when we were growing up, there in the farms, in the Eastern Transvaal, there was this Afrikaner-speaking person who always used to say, "Ekfranite veel van die wêreld nie. Net as steekie brood in a bottle van brandewyn sal maak." That is exactly what this accused person, what Mr. Mnisi is asking for. He doesn't request much of the world. He does not want the world in his hand. He does not request for gold. He does not request for petals or diamond. All that he is requesting for is that he be afforded the right that the Constitution confers on him as an accused person in terms of Section 35(3), that he be afforded the opportunity and facilities to go and prepare for his defense. Now, we are further submitting, my Lord, that this information, which would have been as a result of his preparedness, would bring some kind of objective evidence to the court. That is not based on speculative hypothesis. The nature of the evidence that he seeks to produce to court during the cross-examination of Warrant Officer Mawasa carries a significant weight in assisting the court to come to a just decision of the case, as this is called for in Section 167 and in Section 186, the just decision of the court, without which, my Lord, there will be doubt as to whether the decision that the court would have arrived at without affording Mr. Mnisi this opportunity to go and prepare for his defense would be just. Now, he does not do this in vacuum, my Lord. He definitely does not do this in vacuum. He is drawing a parallel or a comparison or an analogy between what is happening to him now and the case of accused number 2, that is Mr. Ntanzi. And I'm sorry to even mention his name in this case, but it is only fair that that parallel should be done. Now, the court will remember that there were also allegations of a similar nature that were raised against Mr. Ntanzi, who is accused number 2 in this matter at the very beginning of the trial. And if my memory serves me well, he got referred to for dental assessment. The result of his assessment were presented to court as evidence through Dr. through Dr. Tokwe. Thank you, Mr. Ramsupi. Through Dr. Tokwe. And as a result of the report that was placed before court, Mr. Ntanzi was able to challenge the state's case on that aspect of the evidence because he had all the information at his disposal and having had been accorded sufficient time to prepare for his defense in this regard. It is thus inconceivable that the applicant can be denied a similar opportunity. Denying him that opportunity will be contrary to the spirit of the Constitution and will violate Section 9 of the Constitution of the Republic of South Africa, Act number 108 of 1996, which states as follows. Now, Section 9 of the Constitution deals with equality. And Section 9.1 of the Constitution says, everyone is equal before the law and has the right to equal protection and benefit of the law. Everyone is equal before the law and has the right to equal protection of the law. Again, my lord, I went through the Constitution. I could not find a clause that says everyone is equal before the law, but some are more equal than others. It really can be that Mr. Ntanzi, in the preparation of his case and the cross-examination and in the cross-examination of witnesses who had come to testify on whether or not he had a golden teeth at the time at which this offense was allegedly committed, had an opportunity to prepare for that defense. And the same opportunity does not get afforded to accused number 3, who is an applicant in this matter, who gets confronted with this new evidence 23 months after the commencement of the trial, who gets confronted with this evidence that the state had in its possession for 5 years. I'm talking about the prosecution now. That the state has been in possession of this information for almost 10 years. I'm now referring to the police. That will not only be fair, my lord. Accused number 3 will be denied dignity not only in this trial, but in heaven and earth. Will not be accorded to the proper dignity. Now, I've said, my lord, that our application is based on certain pillars. That was just but what the Constitution was saying. Now, we further submit that the approach to a fair trial right was enunciated as follows by the Constitutional Court in the case of State versus Japai. Now, the citation of that case is a case that was heard in, or the citation is 2005, volume 1, SACR, page 215. It's a Constitutional Court decision and the judgment was delivered on the 18th of February 2005. My memory serves me well. I think it was delivered by Judge van der Westhuizen, and let me just confirm that. Yeah, I think it was the Honorable Judge van der Westhuizen, as he then was at the Constitutional Court. Now, this is what he said on paragraph 26 of his judgment. Now, he says, Section 35(3) of the Constitution states that every accused person has a right to a fair trial. The basic requirement that trial must be fair is central to any civilized criminal justice system. It is essential in a society which recognizes the right to human dignity and to the freedom and security of the person, and is based on the values such as human rights and freedoms, the rule of law, democracy, and openness. The importance of universality of the right to a fair trial is evident from the fact that it is recognized in key international human rights instruments. I'll come back to the key international human rights instrument. Now, I am wondering, my Lord, whether I need to amplify what section, what the Honorable Judge van der Westhuizen says in paragraph 26. Because if I were to attempt to do that, I would basically spoil what he eloquently so proffered. Let it stand as is. Now,
sorry, is it not Ackerman?
No. Ackerman, I think, was involved in case versus Tukuta. Yes. Now, at the time when we were also brainstorming this possible application, the court remarked that if needs be, the applicant can also refer to the Canadian laws and all those international instruments, my Lord. Indeed. What Judge van der Westhuizen, Westhuizen or van der Westhuizen, I think it's van der Westhuizen, but I'll confirm that, my Lord, says in his very last paragraph of the extract that I've referred to the court to, says the importance and universality of the right to a fair trial is evident from the fact that it is recognized in key international human rights instrument. And indeed, Article 14 of the International Covenant on Civil and Political Rights states as follows: in the determination of any criminal charge against him, everyone shall be entitled to the following minimum guarantees in full equality. In full equality. Number A, to be informed promptly and in detail in a language which he understands of the nature and cause of the charge against him. Number B, to have adequate time and facilities for the preparation of his defense and to communicate with counsel of his own choice. I think I need to emphasize what number B says. To have adequate time and facilities for the preparation of his defense and to communicate with counsel of his own choice. And number C says, to be tried without delay. Now, being confronted with new evidence 23 months after the trial had begun, exclusively new evidence, that cannot be said that that's been a trial without a delay. Because it is that after 23 months, after the commencement of the trial, that the state then jumps up and says, no, but we've got new evidence against these accused. And this position, my Lord, may I respectfully submit, should be differentiated from a position where the state comes and says, we were not aware, we did not have this information, we only got this information in the course of the trial. Because I know from a prosecution background that when a case is proceeding, the state does not stop to investigate up until the trial is concluded. But this is not a position in this case. The state in this case had this information at their disposal even at the time when the accused were called upon to come and plead. As I've said, the investigating team had this information at their disposal for almost 10 years. And as I've said, the prosecution had been in possession of this information for more than 5 years. Why has it not been made available to the defense at that moment in time? It remains a mystery. But be that as it may, my Lord, it is our submission that the making available of this information at this hour of reckoning simply constitutes a justice delay, which is a justice denied. The state can therefore not come back and say, yeah, no, but if this accused person would be entitled to a further postponement or be afforded the opportunity to go and prepare his defense for this, come and cross-examine a warrant officer, Mabaso, that is going to delay the state. That will be a sin for the state to do that, my lord. That will be unheard of. That will be a gross irregularity of a submission, because this is a bed of roses that has been made by them. I've got no reason not to say that it's a bed that they made themselves and they've got to lie on it. But Article 10 of the Universal Declaration of Human Rights Article 10 of the Universal Declaration of Human Rights states as follows, that everyone is entitled in full equality to a fair and a public hearing by an independent and impartial tribunal in the determination of his rights and obligations and of any criminal charge against him. Now, the operative word in that Article 10 on the Universal Declaration of Human Rights, it's the word fair, that everyone is entitled to a full equality to a fair and a public hearing. Will it be fair for the accused to be afforded an opportunity and facilities to go and prepare for his defense in order to come and challenge the state's evidence on an evidence that he gets confronted with, which is new, 23 months after the commencement of the trial? Will that be fair? If anybody will say, my lord, that would not be fair, then I would be allowed to I'm going to request to confront that person and say to him, they really don't understand what the meaning of fairness in legal context is. Because on a number of occasions, this court has been referred to an authority. I just forgot that authority. It's just coming to my mind now. Fairness must not only be fairness in the instance of the accused person, but it must also be fairness at the instance of those that are being affected by the crime, the society.
State versus king.
That's king, my lord, yes. Those are the ethos of fairness. Those are the ethos of fairness. Accused, in other words, accused person must appreciate that he is not the only beneficiary of fairness in a trial as it proceeds, but the state as well must also acknowledge, as it represents the 64 million of the South African population, the 64 million people in South Africa that are looking at him. The state must also acknowledge that fairness is not only about that 64 million, it's also about the accused person as well, particularly if his reasons for request of fairness are well grounded, such as a method such as this one. Now, I'm proceeding with the international instruments. Now, they are referring to this as article. In South Africa, we would have referred to this as section, but they choose to use the word article. And then Article 6 of the European Covenant for the Protection of Human Rights states as follows: in the determination of his civil rights and obligations, or of any criminal charge against him, everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. Again, that phrase, fair, fairness at the hearing of a criminal matter, crops up again, my lords. I need not amplify this. It is exactly what is stated here. That has been the European Covenant for the Protection of Human Rights. Now, in our continent, it does not mean that there's no recognition of fairness in a criminal matter. And this is what the African Charter of Human and People's Rights says on Article 7. It's a very long article, but with the permission of the court, let me read it. Now, it says, Article 7, sub-article 1, every individual shall have the right to have his cause heard. His cause heard. This comprises the right to an appeal to a competent national organs against acts of violating his fundamental rights and recognized and as recognized and guaranteed by conventions, laws, regulations, and customs in force. The right to be presumed innocent until proved guilty by a competent court or tribunal. The right to defense, including the right to be defended by counsel of his choice. The right to be tried within a reasonable time by an impartial court or tribunal. No one, that's now sub-article 2, no one may be condemned for an act or omission which did not constitute a legally punishable offense at the time it was committed. No penalty may be inflicted for an offense for which no provision was made at the time that it was committed. Punishment is personal and can be imposed only on the offender. Now, Article 7, sub-article 1, paragraph C says the right to defense, including the right to be defended by counsel of his own choice. That might sound a little bit irrelevant in this application, my lord. Yes. This article simply says accused person has got the right to defend himself. Now, how does an accused person defend himself when he's not afforded the opportunity to prepare, when he's not afforded the opportunity and facilities to prepare for his defense in attaining what is universally known as a fair right to a trial? That will be virtually impossible. As I've said initially, that if such were to happen, then accused person would have been denied the necessary dignity and respect in the trial in which he is involved, my lord. Now, in State versus Zukuta and others, I think this is a judgment of the Honorable Judge Ackerman. It's a judgment it's very, the citation there, it's 2011 Butterworth Criminal Law Report, page 1252, Constitutional Court. And it was penned, or it was given on the 27th of September 2000. Now, this is what the court had to say in Zukuta. Now, in paragraph 9, the court said, as was laid by this court in Zuma's case is also a constitutional court judgment. Yes, my lord. And it does not refer to the former state president of the country, Mr. Jacob Kedlayi Zuma. It refers to another Zuma. An accused rights to a fair trial under Section 35(3) of the Constitution is a comprehensive and embraces a concept of substantive fairness, which is not to be equated with what might have passed muster in our criminal courts before the Constitution came to force. These comprehensive rights are specified in paragraph A to O of subsection 3 of section 35 of the Constitution. The words which include the right preceding this listing indicate that such specification is not exhaustive of what a right to a fair trial comprises. It also does not warrant the conclusion that the right to a fair trial consists merely of a number of discrete sub-rights some of which have been specified in the subsection and others not. Now, the right to a fair trial is a comprehensive and integrated right, the content of which will be established on a case-by-case basis as our constitutional jurisprudence develops on section 35(3) of the Constitution. Now, at paragraph 11, the court continued to say the following. At the heart of a right to a fair criminal trial and what infuses its purpose is for justice to be done and also be seen to be done. But the concept of justice itself is a broad and a Proctean concept. In considering what lies at the heart of a fair trial in the field of criminal justice, one should bear in mind that dignity, freedom, and equality are the fundamental values of our Constitution. An important aim of that right to a fair trial is to ensure sufficiently that innocent people are not wrongly convicted because of the adverse effects which a wrong conviction has on the liberty and dignity and possibly other interests of the accused. As I've said, my lords, initially, or in the course of my submission, I am wondering if I need to amplify this, because I am afraid that should I start to amplify this, I am going to spoil what the Honorable Judge of the Constitutional Court so eloquently proffered in this paragraph in his analysis of what a fair criminal trial is. I would rather not spoil it by trying to emphasize it, my lord. But now, I'm coming, my lord. Yes. Yes. I think the Honorable Judge Kendrick was involved in the Zuma case. Yes. Now, the court, as I've said initially, that it hinted that he's not aware of a specific procedure that would allow the court to deal with the situation which is the basis of this of this application. And this is my submission in that regard, my lord. Now, I'll come and deal with the provisions of section 173 of the Constitution. We are saying in our heads of argument that, as we have mentioned in paragraph 20 of our heads of argument, the Criminal Procedure Act does not have a specific provision which deals with the matter under consideration. In dealing with this apparent lacuna, the court in the Tsagudza case stated the following at paragraph 10, and it said, it cannot be assumed that a fair trial, as required by section 35(3), can only be achieved by one system of a criminal procedure. I think I need to repeat this. It cannot be assumed that a fair trial, as required by section 35(3), can only be achieved by one system of criminal procedure. There may be more than one way of securing the various elements necessary for a fair trial, and provided the legislature devises a system which effectively secures such rights, it cannot be faulted merely because it settles for a system which departs from past procedures. The norm prescribed by section 35(3) is a fair trial. The question to be determined in each case is whether the criminal procedure scheme or the relevant part thereof, devised by the legislature, whatever its form, conforms in substance to that norm. Now, again, my lord, I do not wish to amplify what the court said in this Zuma case. I mean, in this Tsagutsa case that I've just referred to the court to. This simply means that even if the Criminal Procedure Act does not make a provision for a specific procedure on how circumstances such as this one should be dealt with, the courts are called upon, if that would not be a violation of the law, to implement or to see to it that the spirit of the Constitution is implemented or is given effect to, my lord. Now, section 173 of the Constitution states as follows: inherent power. The Constitutional Court, the Supreme Court of Appeal, and the High Courts of South Africa each has the inherent power to protect and regulate their own processes and to develop the common law, taking into account the interest of justice. Let me repeat this. Taking into account the interest of justice. In other words, the Constitution was well aware, or the Constitution drafters were well aware, that there may arise circumstances in the course of trials, whether in criminal trials or in civil trials, in arbitration matters, etc., 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 where the effect of the Constitution should be given effect to. However, because of lack of a specific procedure in dealing with that particular scenario, then the court might come and say, no, but there's no law that says we should do this. There's no law that we should do that. Then the drafters of the Constitution thought ahead and said, no, Mosi, the Constitutional Court, the Supreme Court of Appeal, and the High Court, let us give them inherent powers to regulate their own processes and to develop the common law. In other words, even if such procedure is not specifically stated in the subordinate legislation, that should not be a bar to them not to give effect to the spirit of the Constitution. They can simply invoke their inherent powers and say, no, in the interest of administration of justice, and in this case, in the interest of a fair trial in terms of section 35(3), we are going to adopt this process for as long as nobody is prejudiced, for as long as nobody is going to cry foul of the process that we are going to implement. We are going to do this. That is the power. It's a power I wish I had, my lord, as a person. Unfortunately, the Constitution doesn't really warrant that individual people should have these powers. These are all embracing powers, inherent powers. But they are not supposed to be utilized in a vacuum. They are supposed to be utilized in instances where the interest of justice demands. Now the question is, do interest of justice demand that accused number 3 be afforded the opportunity to go and prepare and the necessary facilities to go and prepare his defense on the new evidence that has been introduced by the state? 23 months after the trial has commenced, when the state had this information for 10 years in their possession, when the state has this information for 5 years in their possession, should the court really invoke these powers in order to see to it that Mr. Meyiwa is accorded a fair trial? I am looking forward with keen interest to receiving an unfavorable answer to that question. Thank you. I'm not done, my lord.
You're done?
No.
Oh, okay, fine.
Thank you, my lord.
I thought you said you didn't say thank you. Once you're finished.
No, I'm saying I am looking forward to receiving an unfavorable response to the answer that I've asked as a solilog. And I was saying thank you to that, my lord. Now, we further amplifying what has just been mentioned by the inherent power as follows, my lord. The provision of this section ensure that when the courts, now which section? Section 173. Ensure that when the courts mentioned therein are called upon to give effect to the spirit of the clauses of the Constitution, are not limited in their duties to do so for want of a standing procedure in circumstances where one does not exist. Now, the Constitution is the supreme authority that is superseded by none. The preamble to our Constitution states as follows, my lord, that the Constitution is adopted as the supreme law of the Republic so as to heal the divisions of the past and establish a society that is based on democratic values, social justice, and fundamental human rights. Does what Mr. Mnube request this court to accord him not a fundamental human rights? I am also looking forward to receiving an unfavorable response to this question, my lord.
I don't recall this.
Yes.
Do you know what strikes me? Because I think aloud.
Yes, my lord.
I thought it says South Africa belongs to those, all those who live in it. Is that how it starts, the preamble?
I've got a constitution here, my lord.
No, you said the preamble.
Yes.
Yeah, does it say that?
Let me say part of the preamble that is relevant to the case that I'm dealing with here, my lord. I'm looking at a clause that says South Africa belongs to all those who live in it. It does not say. It says we, the people of South Africa, recognizes the injustices of the past, honor those who suffered for justice and freedom in our land, respect those who have, let me wear my spectacles. Thank you, my lord. I've just worn my spectacles now. It says, respect those who have worked to build and develop our country. Those who have worked to build and develop our country, and believe that South Africa belongs to all those who live in it, united in our diversity. We, therefore, through our freely elected representatives, adopt this Constitution as the supreme law of the Republic of South Africa. The court just asked me whether it says all those who belong to, believe that South Africa belongs to all those who live in it. Yes, it says South Africa belongs to all those who live in it lawfully.
Yeah.
Yes.
How even unlawful?
Yes, my lord. It does not promote illegalities or unlawfulness. It simply says all those who live in South Africa lawfully.
Right.
I may not get into the terrain, my lord, because that's not the purpose of this explanation. Now, my lord, it says that the Constitution is adopted as a supreme law of the Republic so as to heal the divisions of the past and establish a society that is based on democratic values, social justice, and fundamental human rights. Lay the foundation for a democratic and open society in which the government is based on the will of the people and every citizen is equally protected by the law. Mr. Mnube, Franite Fiel van die Wereld, he does not request a lot of this world. He simply says to the court, can I please be afforded the opportunity and the necessary amenities, which are facilities, to go and prepare my defense, even before I start to cross-examine Mr. Mabaso. Because the evidence that Mr. Mabaso just came up with was a shocker to me. I have not been expecting that I'll be confronted with this evidence 23 months after the trial. He does not ask too much. He simply requests that, my lord. Now, Section 2 of the Constitution states as follows: the supremacy of the Constitution. This Constitution is the supreme law of the land. Law or a conduct which is inconsistent with it is invalid, and the obligations imposed by the Constitution must be fulfilled. Now, Mr. Mnisi is not standing there and saying, can you please hear me and hear me well? I am crying for the following, basing his pleas on nothing, simply basing his pleas on the Constitution of the Republic of South Africa. And Section 2 of the Constitution says that the obligations that are imposed by the Constitution must be fulfilled. Section 35(3) is a right that is imposed by the Constitution. Why should it not be imposed or fulfilled? Fulfilled, actually, that's the way that is used by the Constitution. Why can't it be fulfilled? Yet again, my Lord, I will be waiting very keen for an unfavorable answer to this question. Now, we further submit, my Lord, that an institution, including courts, will thus not be castigated merely because that system or the court are settling for that institution or the court are settling for a system which departs from past or standing procedures in its quest to say that justice is not only done, but is also seen to be done. Those who understand the phrase justice being seen to be done, those who understand the phrase justice being done and being seen to be done would basically understand what it really means in the context of this case, my Lord. Now, as we conclude, my Lords, we are saying that the applicant in this matter does not request for something that is out of the ordinary. He simply implores this court to allow him to utilize his constitutionally guaranteed rights in the conduct of his defense during this trial. There is no harm which will be suffered by anyone in him being allowed to utilize the said rights. However, the opposite is detrimental, as was expounded in the Tsukutsa case, where the court held in paragraph 11 as follows: that an important aim of the right to a fair criminal trial is to ensure adequately that innocent people are not wrongly convicted because of the adverse effects which a wrong conviction has on the liberty and dignity and other interests of the accused. Now, we are saying, my Lord, that on the conspectus of the merits of the case and on the basis of the above mentioned, being the Constitution, being the cases that the court has been referred to, it is respectfully submitted that the applicant has successfully made a case to have this request granted by the Honorable Court. I would further add, my Lord, that I think it's a point that I've already mentioned. I'm not even so sure. No, no, my Lord. That I'm not so sure whether I've mentioned the fact that I have not even taken proper instruction from Mr. Mnisi with regard to the cross-examination that I need to have to the accused. But if I've mentioned that, so far so good, my Lord. But finally, my Lord, if the Constitution was a human being, if the Constitution was a natural person as opposed to a juristic person, this is what the Constitution would have said, an open quote. It would have said, "Dear Honorable Court, please do not be deterred or dissuaded from giving effect to the spirit of the provisions of the Constitution for a want of a specific procedure from the Criminal Procedure Act. The Constitution has empowered you in terms of Section 173 to protect and regulate your own processes, if that is in the interest of administration of justice." And then the Constitution will close its case, will close its code. That will be our submission, in support of the application by accused number 3. Thank you, Coming back.